A blended family is a couple who may or may not have children together, but they do have children from a previous relationship. So a more traditional approach to estate planning typically doesn't work for a blended family because there's extra considerations. For most couples, their major assets, such as their property or bank accounts, are owned jointly. What this means is that when one of them passes away, there's a right of survivorship to the surviving person, and that asset will pass automatically to them, regardless of what the will says. The risk of not having a good plan in place is that you have children who may receive nothing from your estate, either at the time of your death or when your spouse passes away, or children who are put in a position that in order to ensure they receive something, have to challenge your estate, and that can be a very expensive and an emotionally difficult process for them to go through. Some other ways of estate planning not using the will might be to use a life insurance policy and naming your children as the beneficiary of that, or sharing that with your spouse. Another example would be tax-free savings accounts sometimes are a good way to leave gifts to children or divide it between your children and spouse to ensure that everyone's accounted for in your estate plan. For a blended family, we always recommend that when you're estate planning and considering what you wish to do with your wills, that you get legal advice so that you can make informed decisions and understand how things will work if something happens to you. Because ultimately, my job as an estate planner is to help couples with a blended family to make sure that the plan that they have is in place and that their family is taken care of so they can leave here with peace of mind.